21st of April 2025 with me, Jatin Verma. So today happens to be the National Civil Services Day. On this occasion of National Civil Services Day, we are going to discuss about the emerging themes about the civil services reforms, the civil services neutrality and honesty in civil services despite there being a compulsory ethics paper. Rising instances of corruption in the light of capitalism in the light of rising instances of privatization. That is going to be one theme today. We are going to discuss a case study kind of question around it. Then secondly, Jal Shakti wants 2.79 lakh crore rupees more, even though they are demanding 9.10 lakh crore rupees. Why the cost of per tap has risen to 1,37,000 rupees. One tap installation, taking the pipe connection to one habitation and installation of every subsequent tap, the cost has risen to 1,37,000 rupees. Why the cost has risen from 30,000 rupees to 1,37,000? Expenditure Finance Commission of Ministry of Finance raises questions from the Jal Shakti Ministry. This is going to be an important topic today. What are the achievements of Jal Jeevan Mission? What are the objectives? Why has it been extended till 2028? These are going to be the underlying topics. Supreme Court lawyer seeks contempt proceedings against BJP member of parliament for castigating for criticizing judiciary in the public. So what is the theme here? Is the contempt of court proceedings have been sought to be issued against the BJP MP. Irrespective of the political party, is it necessary for Attorney General to give permission for starting the contempt of court proceedings? An important point for prelims as well as mains. Contempt of court proceedings have in the past been sought for or issued against Kunal Kamra, Prashant Bhushan, an eminent lawyer. So what is it there in the Contempt of Courts Act 1971? We are going to discuss that in detail in today's news analysis. Then apart from these three news articles, the civil services reforms, the Jal Jeevan Mission and Contempt of Court, these are the other news articles. On Tamil Nadu bills, persons with disabilities, enabling legislation. This is an editorial, guys, we are going to discuss in today's news analysis. Jal Shakti, this we have covered. Jal Jeevan, these two are interrelated topics, so we are going to deal with them. Why are civil disputes being criminalized? So in the urge to put pressure on the offender or on the accused, civil disputes, the nature of disputes which is civil, are being given the shape or are being presented in the court as if they are criminal cases, so that the element of criminality will put pressure on the accused in check bounce cases under the Negotiable Instruments Act. This is highly important in the arena of the non-performing assets, the loans that are not being paid by the borrowers. The banks are putting the charges of criminalization, okay, instead of it being a civil offense. This is one thing that recently the CJI said, that if anybody criminalizes a matter which is patently civil in nature, which is a civil dispute in nature, then there will be a penalty. Then Vande Bharat has weak defenses against even cows. So if the cattle are crossing the railway track, and if the Vande Bharat, the locomotive, it collides with the cattle, it collides with the buffaloes or the cows, then there is a kind of high danger of the train itself getting toppled, okay, overturned, some of the wagons of the train. Why such safety has been neglected? In that light, Commission of Railway Safety has given a report that the locomotives need to be designed better, or we need to have underpasses for the farmers and the cattle so that they can safely cross the railway tracks. And this is going to be highly relevant for Odisha's elephant corridors. We often see that elephants collide with the railway trains. Now, these are the other news articles, National Civil Services Day, etc. So let's get started with the first thing. Coming to this thing, a Supreme Court lawyer representing one of the litigants in the Waqf Act has written to Attorney General seeking consent to initiate contempt proceedings. So please note it down that for initiating the contempt of court proceedings, I am being very, very slow. We will be dealing with the articles in a beginner friendly manner, so that those of you who are beginners or those of you who have started the preparation 4 months back, 6 months back, they are able to correlate and are able to understand. So even the initiation of contempt of court proceedings under the Contempt of Courts Act 1971 requires the permission of the Attorney General, the government's lawyer, then only the contempt of court proceedings can be started. Okay. Otherwise, contempt of court proceedings cannot be started. Even if it is an MP, even if it is an ordinary citizen or resident of India, to start the contempt of court proceedings, the permission of Attorney General, I'm writing in full, Attorney General is required. Now, what has happened in this context? We are going to discuss this. This is important for your prelims. Okay. Please note it down. Whether the permission of Attorney General is required, I am repeating again. Okay. Whether the permission of Attorney General is required for initiation, for lodging an FIR under the contempt of court proceedings, answer is a bold yes. Okay. So, this point might rise in the light of this case that has come up against a member of parliament who has been criticizing the latest the take of the judiciary on Waqf Amendment Act, on the president, on the time limit being put on the president and governor to approve to assent the bills passed by the Tamil Nadu Legislative Assembly and Kerala Legislative Assembly. We have seen that case. We have been listening about that case. We have dealt with that case in our news analysis also. So, what is that case? The Supreme Court has put the time limit of 1 to 3 months on the governor's power to sign the bills passed by the State Legislative Assembly under Article 200. Under Article 201 also, the President also has been given a time limit of 1 to 3 months maximum, within which the bills duly passed by the duly elected Legislative Assembly of the state, they have to be approved by the state legislative, they have to be approved by the President if in case they are reserved by the governor. But some of the members of parliament, they are not happy with it, including the Vice President of India, who is the chairperson of Rajya Sabha. He has also said that judiciary is using these things as a kind of nuclear missile against the executive. Okay, so he is the vice president. Maybe he would not face any such things like contempt of court, etc. But an MP, a member of parliament, started copying or started making the similar remarks at the CJI, at the Supreme Court. He said that, what did he say? He said that CJI, Sanjeev Khanna, should be held responsible for starting civil wars. What is the meaning of civil war? Civil war is a kind of war within the country where army and government are fighting, maybe. Or in this case, he is saying that judiciary and the duly elected government of India, the Modi government and judiciary led by Sanjeev Khanna are having a civil war, a civil strife as to who is more important, as to who is the actual leader, the parliament, the duly elected government, or the judiciary, right? These two instances have happened in the recent case, in the recent days. Waqf Amendment Act, which has been stayed to some extent by judiciary. Okay, not complete stay, but then the veto power of the governor has also been the subject matter of judicial review in the last few days. So, in the light of these things, now the legislative wing, some sections of the legislature, the parliament, they are saying that judiciary is trying to compete with judiciary versus executive is happening in India. Okay, this is a kind of, the tag that they have given to this thing is civil war. Okay, so why they are using the word civil war? Because the other day, Vice President of India also made similar remarks. He said that judiciary is firing nuclear missiles in the form of Article 142 against the steps taken by the legislature, against the steps taken by the executive. Okay, so our Vice President has been quite vocal about this doctrine of separation of powers. Let me just paraphrase this entire thing that is happening. So one thing, the things that become important for the exam, doctrine of separation of powers. You are also here, I am also here as a teacher. We will see after prelims 2025 as to how many such themes that we have been discussing. Okay, they are going to be asked in the prelims 2025. Doctrine of checks and balances, this also becomes important. Okay, now today we have added another theme, Contempt of Court Act. Contempt of Courts Act. Who has got the power to issue contempt of court charges? Please answer. Does High Court, can High Court also issue the contempt of court proceedings or contempt of court charges? Please answer this thing. Okay, so these three or four themes have occurred in the recent past in the light of the fact that Waqf Amendment Act has been stayed to an extent by the Supreme Court. Second, the veto power of the President of India has also been qualified. Okay, then veto power of the governor, this has also been in current affairs. Veto power of the governor and president. So my dear students, what are you expected from you is the thorough reading of Article 200, Article 201, and then power of the Supreme Court to do complete justice. So what am I trying to do is, I'm trying to phenomenalize, I'm trying to put all the matters that have arisen in the light of this debate in last 5, 6, 7 days. Okay, Article 142, complete justice, power of the Supreme Court to do complete justice. These articles have appeared in the news articles in this controversy of Tamil Nadu versus Governor of Tamil Nadu, R.N. Ravi. Then the Waqf Amendment Act. Okay, so these are the matters from the polity that can be asked from this thing. Okay, so the Supreme Court, the proceedings of the Contempt of Courts Act 1971 it is. Okay, under section 15 of Contempt of Courts Act 1971, and this is to be read with the Rule 3. Rule 3 says that Attorney General's permission is required, his consent is required to initiate criminal contempt proceedings against anybody. Here in this case it is a member of parliament, then also the permission of the Attorney General would be required. Otherwise, even if it is a citizen, then also it will be required. Okay, since Attorney General happens to be the representative of the Government of India, so effectively the permission of Ministry of Law and Justice or government is required. Attorney General will ask from the government whether the permission should be given or not to initiate the proceedings. Okay, now coming to this other issue, see, this is the question 2022. Pursuant to the H.N. Sanyal Committee, the Contempt of Courts Act 1971 was passed. When was the Contempt of Courts Act passed? This is going to be another question. The Constitution of India empowers the Supreme Court and the High Courts to punish for the contempt of themselves. What does the Constitution of India say? My another question to you is, which of the articles empower the Supreme Court? Which of the articles empower the Supreme Court to issue contempt of courts charges? Okay, to level contempt of court charges. So on which committee's report was the Contempt of Courts Act passed? Second, there is another topic to it, Mulgaonkar principles. Okay, Mulgaonkar principles. We will definitely deal with them since this issue has started. Now Mulgaonkar principles will appear in the editorial in the news articles in few days. Definitely I will cover that. If in case they do not, then also we will cover Mulgaonkar principles related to the proper usage of contempt of court proceedings. Okay, so these are the related topics. Now please answer this question. These are the options given at the other slide, the next slide to it. So while you will be downloading the PDF, check the next slide before answering the question in the comment section of the YouTube. This is going to be our third question. Good morning everyone. Moshihur Rahman, Sudha Kumari, Mahipal, Sailesh Kumar. So coming to the other thing, enabling legislation. So this is with regard to Tamil Nadu's reservation bill, in which it has sought to provide reservation to the sections of the disabled citizens. Okay, people with disability, they have been given reservation in Tamil Nadu local bodies. Tamil Nadu local bodies like Panchayati Raj, municipalities. Okay, at all the levels they have sought to give some reservation via nomination to the members from the disabled class. So what is going to be the impact of it? We already have Persons with Disability Act 2016. Okay, so that Persons with Disability Act talks about things like ramp as well as staircase for the people with disability to climb up or to reach up to the bodies like schools or government bodies. So that is why we see that there is a chair lying in every government office these days for the disabled people to be assisted. Even in the airports also we see disabled people get assistance in terms of boarding the flight, where the air hostess and the other people, they assist them via a wheelchair or other equipment lying there, so as to help them to board the flight with ease. So similar kind of things are observed in the government ATMs. thanks to the Persons with Disability Act, you see quite vocal, the ATM machine speaks quite vocally about the options to be chosen. Okay, so this is how the act is creating a kind of enabling environment for the persons with disabilities to access government services. But this is about the accessibility of the government services as citizens. What Tamil Nadu government has done is to empower the people to legislate upon matters for themselves. If there will be enough number of disabled people in the local bodies, which is the main level at which people, disabled people, women, they access the services of the government. If the local people, if at the local level disabled people will be there, they would be able to see for themselves, implement for themselves the facilities that are already guaranteed to them under the statute, but might not have been implemented. So if the disabled people themselves will be there, this will lead to representatives of the disabled people being there in power, being there in the decisive positions, at least at the local level, so as to get the right to persons with rights of persons with disability act implemented in the right manner. Okay, so these things are there. Affirmative action remains one of the, affirmative action means positive action, remains one of the most effective ways of addressing historical wrongs and systemic deprivation, be it for women, be it for scheduled caste, scheduled tribe, OBCs. Okay, now Tamil Nadu government tabled two bills in this context last week to increase the number of persons with disabilities in all the local bodies in the state. It becomes the, with this step, with this legislative step, it becomes the first state to do so in the entire country. Even though we have reservation for women, we have seen that at the national level also recently, the reservation bill was passed for increasing the representation of women in the local bodies after the 73rd and 74th Constitutional Amendment Act. Now, Bill 1 passed by Tamil Nadu seeks to nominate persons with disabilities to all the town panchayats, municipal councils and municipal corporations with amendments to Tamil Nadu Urban Local Bodies Act, urban local bodies. Okay. Second, to bring into law the decision to nominate one person with disabilities to all the village panchayats. So, Act 1 deals with the local bodies. Act 2 of Tamil Nadu State Legislative Assembly deals with the nomination of the disabled people, at least one person each, to all the rural local bodies also. Okay. So, positives of the move are going to be, this step will ensure dignity to the people with disability. Okay, we have coined the terms like Divyangjans, people with special abilities. Okay, so much of terminology has arisen, but has it given dignity to the people? Okay, now we can expect some semblance of dignity with this step of the Tamil Nadu government here. Okay, and eroding the stigma and discrimination. This change would empower the community, disabled people's community, involving their representatives in the decision making at the grassroots level. So this is going to be the positive step. Then it is the role of the government to take along its citizens, particularly the citizens who are deprived, who are vulnerable, who are disadvantageous in the form of disability, etc. Okay, those who may have an impediment that might come in the way of their harnessing equal opportunities. So disabled people, even though they have right to a right of persons with disabilities act, but they find difficulty in getting that implemented. We have seen various organizations, non-governmental organizations, advocating for proper implementation of right of persons with disabilities act. Now I ask you a question: has India ratified the convention? What is the name of the convention dealing with the disabled people? Okay, so please name the convention, or please also answer whether India has signed it or ratified it. Does it talk about the political representation? We have representation in administration. We have people like Ira Singhal, etc., getting quite a good rank in the IAS examination. Okay, rank 2, rank 3, fighting a legal battle with the Department of Personnel and Training, Ministry of Personnel and Training. Okay, so those steps have been taken by the government, but this is the first step taken by the Tamil Nadu government. In the light of this step, please answer: does the United Nations Convention for Persons with Disabilities, does it talk about political representation of persons with disabilities or not? Okay, now Reservation for women in local bodies. After the 73rd and 74th constitutional amendments to the constitution that allowed for 1/3 representation of all seats in Panchayati Raj institutions and urban local bodies, okay, some states including Tamil Nadu have increased this to 50%. So the writer here is talking about the reservation for women in certain states has been increased to 50%, even though the nationally passed Constitutional Amendment Act mandates only 33% of reservation for women at all the levels. Okay, what is the constitutionally guaranteed reservation for women in Panchayati Raj bodies? 33%. But Tamil Nadu and certain other states, they increased the reservation in their respective states' jurisdiction to 50% for women, which is a good step. But then we also know about the phenomena of Pati Pradhan, Sarpanch Pati. Okay, so the de facto leader is the Pati, the husband. Okay, despite there being reservation. Since then, the very rancorous and long drawn out battle was finally resolved in 2023 with the Women's Reservation Act being passed for 33% reservation for women in Lok Sabha and state legislative assemblies. Okay, this will be effective after the publication of census. But the problem is for local bodies, for Lok Sabha and other bodies, okay, the 33% reservation that has been passed by the government will take effect after the publication of the next census. When will the census be passed? God knows. Where is God? God knows. Okay, so the problem here is the clause that has been inserted is women's reservation. We are talking about the reservation of women's bill, okay, for reservation in Lok Sabha and legislative assemblies. Now the reservation has been mandated, but has it come into effect? No, as of now, it hasn't come into effect. Why? Because the act says that, the notification of the act says that it will come into effect after the publication of the next census. Census has not been conducted, and this is one of the reasons that is why this hasn't come into effect. Okay, now Sarpanch Pati phenomena, given the initial experience, the writer is quite hopeful. Writer says that initially these reservation measures etc are not accepted by the society, the vested interest of the society, that is Pati, the husband here. Okay, so these husbands who have been hogging the limelight thanks to the patriarchal nature of Indian society, where brother, husband or brother-in-law will hog all the limelight, they would want to be in actual position of power. Women have just been the facade of it, they have just been the face of the sarpanch, whereas the actual decisions are taken by the husbands or the male members of the family. So that was the experience with 73rd and 74th Constitutional Amendment Act in the initial years, let's say in the 10 years, 20 years. Right, but gradually we see that women come to the fore, women actually start taking decisions. Various studies that have appeared in the Yojana magazine, Kurukshetra magazine, and various studies conducted by Ministry of Panchayati Raj have highlighted that where women are the leaders in the form of sarpanch or panch, one of the elected representatives, there the condition of women and children has been better, in the sense that there in those villages where women is the leader, where women is the sarpanch, the piped water connection, the implementation of LPG scheme, the cylinder scheme or Pradhan Mantri Awas Yojana scheme has been better. The women related schemes have been implemented better in those villages where women are the leaders, political leaders themselves. So since these things have taken their time, the writer says that the recent step of the Tamil Nadu government to provide reservation to the disabled people might be resisted at the ground level initially, might not be taken receptively, positively. But after the experience from the women reservation, where women had to fight a long battle, both in the form of electoral contest outside and in the form of the contest within the four walls of their house, between their husband, between their brother and between their male members of the family, whether they can take the steps like steps which are for the betterment of the women. They had to fight they had to wage the two electoral battles, one inside the house and one outside. Similarly, disabled people will also have to overcome two disabilities, one the physical disability and one the second the societal disability, that of fighting the social taboos, the stigma, the stigmatization of the disabled people, whether the person who is disabled himself will be able to enable the society. These are the stigmas, the taboos against the people, disabled people, but gradually the writer says they will be able to win over these battles also. Okay, now coming to the next topic of the day. Jal Shakti Ministry wants 2.79 lakh crore rupees more for the flagship water scheme. But the Expenditure Finance Commission, the body that approves these expenditure, increase in the expenditure, has approved only half the increase. Why the increase has been sought by the ministry for its flagship patented program, that is tapped water supply program, Jal Jeevan Mission. Okay, faced with sharply rising costs and doubts regarding the potentially inflated work contracts. So there has been a doubt cast on the Jal Shakti Ministry of Water Resources, that it is artificially escalating or inflating the cost of the work. The contractors are being given the benefit. Okay, a panel led by Expenditure Secretary, Department of Economic Affairs. There are many departments: Department of Finance, Department of Expenditure, Department of Economic Affairs in the Ministry of Finance. So the Expenditure Secretary has proposed a substantial 46% decrease in the central funding requested by the Jal Shakti Ministry through December 2028. Now the tenure of the mission was till 2025. Jal Jeevan Mission was supposed to complete the supply of tapped water to all the rural habitations, to all the households in the rural habitations, totaling to 16.8 crore total households. They were supposed to be provided with tapped in-house water supply, so that the women don't have to carry water over their head and travel long distance by walk. Okay, so that they can save their time, that can save the women from the instances of molestation and rape, etc., or death in case of scorching heat, in case they were to travel long distance. So these type of novel objectives were there for the empowerment of women through Jal Jeevan Mission. But the data that has appeared, it says that for installation of one tap at a cost of rupees 30,000 initially proposed in 2019, the cost was 30,000 rupees. Okay, now the ministry says that from 30,000 rupees, now they want for every tap to be installed 1,37,000 rupees. Why such an increase is what is expenditure panel asking. Okay, Expenditure Secretary of the Ministry of Finance is asking, why so much of increase? See, we can level the allegations of corruption also. We can say that government is asking more money after the program has started, when the initial money requirement was 30,000 rupees per tap. Okay, now it's not that it is a gold tap. Okay, tap is made in gold or silver or some other stone, right, or some other metal. No, it's about the initial, the backend supply, the infrastructure that needs to be created. Let me draw some more lines to help you understand. Tap is the last culmination, the final culmination of the efforts of the ministry. Fetching the taps, fetching the water, okay, from the back end requires the money, installation of the pipelines. And it is not only this small pipe, it is about the pipes in the big diameter. Okay, so those pipes which will supply the water to the rural habitation, the rural village, that requires a lot of money. Okay, now when the program is in the last leg of its implementation, whereby 12 crore houses have been covered and additional 4.8 crore houses need to be covered, maybe these 4.8 crore houses are located too far away from the water treatment plants or the source of water supply. That is why in the initial stage, the cost was 30,000 rupees for installation of every tap. Okay, initial phase of the program that started from 2019 required lesser money. But now, because the program is in the culmination stage, seeking to achieve its objective in the full measure, it might require some more money, additional money, but still the amount of money is questionable. 1,37,000 rupees. It may sometimes the doubt comes into the mind is maybe they are installing Sone ki tap, gold tap, where the water will also be having some element of gold or silver or maybe platinum, right? So on a lighter note. So the point is, Jal Jeevan Mission launched in August 2019 aimed to provide tap connection to approximately 16 crore rural households by the end of December 2024. But only 75% of this target, around 12 crore connections, was achieved within the initial 5-year period. Okay, now please answer, in the Jal Jeevan Mission, is there any provisioning for the water treatment? Okay, water supply by fetching the water from the ground is one thing. We are depleting the groundwater resources, but a critical analysis also warrants us to know whether there is a facility for groundwater rejuvenation, groundwater replenishment, groundwater recharge, in simple words. Okay, so those are the critical elements that the next phase of Jal Jeevan Mission or Jal Jeevan Mission 2.0 should take care of. Otherwise, it will be like creating a problem of sewage, creating a problem of wastewater, leading in its turn to problems like diarrhea, etc., waterborne diseases. Or secondly, most importantly, Niti Aayog report says that there will be water scarcity in 40 districts of India. Maybe the number is less, the number that I'm quoting, okay, but they highlighted critical water scarcity will be observed in Anantnag and various other districts. Okay, not Anantnag, Aurangabad district, etc. Okay, so there will be critical water scarcity in Shimla, etc., Himachal Pradesh, already being witnessed. By 2030, this problem will be aggravated to a great level. So, factual part. Now, the other factual questions that I ask you is, what is the contribution of the center and the states in this Jal Jeevan Mission? Please answer these questions. This is my analysis. Your ability to answer these questions, your answerability will determine what is going to be your analysis, what you are actually going to take to the examination hall. Very humbly, very politely, I'm saying, all this is something that is deposited, that is memorized by me over the years, by repetitive reading, etc. What are you going to take away will depend upon what are you going to answer. Because when you answer that information, you put in an effort, and when you put effort, you memorize the thing. Otherwise, it's going to be a cakewalk or a fake walk for you. Fake in the sense that you are learning, but you are not making it as your own knowledge. Clear? So just pull out the details, read a bit of more information, and try to make notes out of it. So the liability estimated at over 1.25 lakh crore rupees over the next 4 years might need to be covered. So the expenditure secretary has said that instead of the demand of 2.5 crore rupees, 2.79 crore rupees, we will sanction only 1.25 lakh rupees. The responsibility to bridge this funding gap could fall on the states. Okay, since center has not approved the complete 2.79 lakh crore rupees that were being demanded by the ministry, that were being demanded by the Union Jal Shakti Ministry. Now, funding demands and expenditure finance committee. Okay, recommendations. The Jal Shakti Ministry requested 2.79 lakh crore rupees in the central funds from the budget 2025-2026, but it has been given an approval of just 1.45 to 1.5 lakh crore rupees. So the additional money will have to come from the state governments. Okay, the expenditure finance committee also reduced the overall mission outlay to 8.69 lakh crore rupees instead of the demand of 9.10 lakh crore rupees. Okay, so this is there. Now, cost escalation and the state level approvals. Mission dashboard. There is a Jal Jeevan Mission dashboard that is given on the ministry's website. It shows that the states approved schemes worth 8.07 lakh crore rupees during the initial 5 years, 2019 to 24. That was the original target year. Okay. So these schemes now, they come with the year of start and the year of ending also. This is called as the sunset clause. So what used to happen with the government scheme was their sun would rise, okay, in the sense that scheme would be launched, but it will go on continuing, leading to a lot of expenditure, wastage, okay, and budgetary outlays. Thanks to the insertion of the sunset clause now, when the scheme is launched, the at the date of the launch of the scheme itself, the year of starting of the scheme, in this case Jal Jeevan Mission case 2019, okay, Jal Jeevan Mission's case, and the ending year 2024, that is also mentioned. Any approval of the scheme, any continuance of the scheme beyond 2024 will again require the passage of the scheme. Critical appraisal will be there. Expenditure Finance Committee will review it, and then only it will be approved. Critical appraisal as to why do we need to continue beyond the originally mandated period. Originally approved period was 2019-2024. This was the period. Okay, why do you want it to continue till 2028 now? Critical questions will be asked. So this is called as sunset clause. Okay, sunset clause. This has become a part of almost all the government schemes approved after 2006. Clear? This helps in saving the budgetary outlays for various schemes. As I said, I'll be doing the news analysis in a very beginner friendly manner. The ones who are not aware of these things, why the terminating year, why the ending year is also mentioned, you will also get to understand. Now, this substantial increase in the costs is likely the reason for Expenditure Finance Committee's decision to reduce the outlay and the central share. The Jal Shakti Ministry reportedly defended the Jal Shakti Ministry, since it is asking for money, it will defend only. It is defending the decision that why the cost has increased. Okay, initially they said that the mission required more money in 2019 itself. In the same year 2019, the Jal Jeevan Ministry had demanded more money, but the expenditure was curtailed, it was suppressed, and the program was launched with lesser resources, just to show up the good numbers in the budget, that revenue deficit or capital deficit or the combined fiscal deficit would be less. But the reality is that the ministry says that in the initial year, first year itself, we had demanded more money in 2019 itself. Clear? Works worth 32,000 crore rupees in Maharashtra, Bihar. So this is all we have understood now. These lines are not required to be read if you have understood the essence of it. Now, government's response and calculation. The center has already paid 2 lakh crore rupees approximately to the states during this thing. Okay. The Expenditure Finance Committee recommendation of 1.51 lakh crore rupees represents the remaining share of the center based upon their appraisal. Now, coming to another thing, the same related thing. Okay. Finance Ministry is asking the justification for why the increase to why the per tap installation cost, per tap connection cost has increased from 30,000 rupees during 2019-24 to rupees 1,37,500 rupees. So I have already explained you the reason that as we proceed towards the last leg of the Jal Jeevan Mission, the previously unapproachable, unreachable villages will require more money. Pipelines installation will be longer. The distance to be traveled by the pipeline will be longer. So that is why the per tap connection cost will rise in the last leg. Okay. Like for example, when you prepare for the UPSC or when you are running in the race. Okay. First few meters of the race are very easy because you are energetic. Okay, and the distance to be covered is less, seems to be less. But when you are in the last lap of your race, it requires a lot of effort, money, energy. Similarly, same thing happens with the previously unapproachable villages which were quite far from the source of water. Now they will be reached out. Now the water connections would be provided in those villages. We have already plucked the low hanging fruits in the form of providing water connections to the easily accessible rural villages, rural habitations, rural households. Now in the last leg, we need to put in more effort in the form of money and in the form of the water sources. Okay, so Department of Economic Affairs, what is its role? Expenditure Finance Committee, under whom does it come? It comes under Ministry of Finance. You should be knowing this. Now coming to the other news article. Okay, tender premium. Jal Jeevan Ministry has been accused of tender premium, that they are paying premium on the tender. Some tender cost has been escalated for the private applicants of the tender who want to do this work by taking money from the government. The private bidders, they are asking for more money, and Jal Jeevan Ministry has been accused of authorizing the more money. Okay, so this is it. Tender premium is defined as the difference between the actual tender cost, that is 1,37,500 rupees for every tap connection, and the government schedule of rates. Government schedule of rates said that it is going to be less, but actual cost is turning out to be more. So the difference between the two is known as tender premium. Clear? Now coming to this thing, why are the civil disputes being criminalized? Okay, so what happens is, if there are civil disputes related to check bounce, bank gave you a loan and you are not able to repay. Bank says that from the initial stage itself you did not have the intention to make the payment. Okay, so your intention was to avoid and evade the payment. You forged the documents, you borrowed the loan with the intention not to pay it. But was it actually the case? No, you had all the intention to pay the loan, but deliberately the check bounce now it's given the shape of a fraud. 420 420 section 420 CRPC is leveled against the people who are not able to pay their loan or who are not able to honor their check. When their check deposited in the bank account of the person to whom the check was given, if the check bounces, the bank or the lender levies the charge of, or he initiates the FIR, the police complaint, with the charge of intention not to pay, section 420. So that is why the Chief Justice of India recently made a remark. He came down heavily. He criticized on this phenomena that there is a kind of utter illegality going on, growing trend of ordinary civil disputes being converted into criminal cases. Okay, so that leads to criminalization of society in a way. Okay, people, the borrower is leveled with the charges of criminal conspiracy, etc., even though his intention was never to not to pay the loan or not to pay the charges due. Okay, so his remarks, the CGI remarks, came during the hearing of an appeal filed by two individuals facing a check bounce case who were also slapped with the criminal charges, including breach of trust, intimidation, and criminal conspiracy. Okay, the Indian legal system has been witnessing a troubling trend of the increasing misuse of criminal law in matters that are fundamentally civil in nature. So there are civil disputes in which the civil charges should be leveled. Sections of IPC, Bharatiya Nagrik Suraksha Sanhita, those sections should be levied which deal with civil offences only. But if they will be given the shape of, if they will be presented in a criminal manner, then that will be a travesty of justice. In a way, justice would not be done in the right manner. So that is why the CJI, they have said that to create pressure on the opposing party, to create pressure on the defaulting party, sometimes the banks, the lenders, or the traders, the merchants, they level the charges of criminal conspiracy, etc., even though that is not the intention of the borrower. This tendency has been seen in civil disputes such as money recovery, check bounce cases, contractual disagreements, inheritance, property partitions, commercial transactions, and others. Okay, so this is there. Now, civil matter yet criminal charge. Why so? So, if we were to boil down this phenomena, matter is civil, but it is given the shape of criminal thing. Okay, this is observed in the dowry related cases. I mean, false invocation of dowry in the case of domestic violence or verbal brawl between the husband and the wife. So many are matters which are civil in nature, they are being presented to the courts as if they are criminal, thereby leading to a situation whereby the accused becomes the victim and the victim becomes the winner. Okay, so victim should be winning the case, but not in a criminal manner, not in a manner that is not the nature of the law, that is not the extent of the law here. Okay, so for the context, if Mr. A, just understand through this example, if Mr. A lends money to Mr. B, which B fails to repay, the matter would traditionally fall under civil jurisdiction. However, if Mr. A comes up with the claim that Mr. B never intended to repay the loan and obtained money through deceit, Mr. A can pursue criminal charges under Section 420 cheating of IPC, now covered under Section 318 of Bharatiya Nyaya Sanhita. Okay, so this is how the matters are packaged in a manner by the lawyers that the civil matters are also getting criminalized. So this is a worrisome phenomena that Chief Justice of India said that this is not the actual mandate of the law, and the law is being twisted to benefit the lender. Okay. So this is there. Now, what did the Supreme Court do in January 2000 in G. Sagar Suri versus State of UP? The Supreme Court had cautioned that it is to be seen by the lower courts if a matter which is essentially of civil nature has been given a clock, has been given the shape of a criminal offense. Criminal proceedings are not a shortcut of other remedies available in the law. Merely by labeling a dispute as criminal, it is not a shortcut. You should explore other possibilities, other remedies available in the law. For example, mediation. Okay. For example, conciliation. For example, compromise between the parties. Checking the actual default. What are the reasons behind the default by a party? Whether business has failed, whether some personal health issue has come up. That is why a person is not able to pay the loan or the borrowed money. So that is what the Supreme Court said, that don't try to criminalize every civil matter. So, second, way forward in the Indian Oil Corporation versus NEPC India Limited case, the Supreme Court made it clear that a complainant who initiates or persists with the prosecution, persists with the criminal charges, being fully aware that the criminal proceedings are unwarranted and his remedy lies only in the civil law. So, if a complainant deliberately tries to push the criminal charges when the matter is purely civil, that person should himself be made accountable to law at the end of such misconceived criminal proceedings. How to make them? The Supreme Court talks about Section 250 CRPC, that in such cases where a person is falsely, where the accused is falsely being implicated with the criminal charges, falsely being trapped in the criminal charges, okay, in such cases, compensation for the accusation, the accused should get compensation without reasonable cause. Okay, so accusations made without reasonable cause, there should be a compensation given from the leveler of the charges, from the petitioner to the accused. So that will be a lesson learned for the people who level false charges of criminal cases. Okay, so this is there. Now our minister says that trade talks in UK, trade talks with the UK for FTA are in the final stages. See, when these uh, trade talks start, it requires a lot of deliberations, meetings. Okay, these deliberations and meetings are given the shape of are given the tag of round, 13th round, 14th round. But since they are long drawn, they happen for years. Now, since UK is also in urgency, India is also in a hurry to conclude a trade deal between India and UK because of the US started US trade war, tariff war. Okay, so that is why the countries are looking for new trade partners in the light of US started tariff war. So one such thing is now that India would be in a position to conclude the trade agreement with the United Kingdoms insofar as no new trade rounds are required. That means we have already concluded the discussion on the fundamental contentions, fundamental issues. Now they said that we are working in an approach. What are the nature of the agreements? What is the name of the agreements that we are going to conclude? Free trade agreement, bilateral investment treaty, and double taxation avoidance agreement. So briefly, let's understand here. First of all, free trade agreement. That means the goods coming from UK to India, okay, on certain goods which both the countries have agreed to, there will be no tax in India on the goods. Customs tax will not be levied in India on the goods coming from UK, and the UK will also not levy any tax on the India made goods, on the Indian goods when they reach United Kingdoms. Okay, no customs tax on agreed list of items. So this is called FTA. Number one. Number two, what is bilateral investment agreement? Bilateral investment agreement. What does it mean by bilateral investment agreement? So bilateral investment agreement means when the companies of UK, okay, UK's company is making investment into India. For example, Vodafone is a UK company, okay. So this company, its investment, etc., will be protected. Protection of investment, okay. Protection of investment for this company in India. So what do we mean by protection of investment? For example, if Vodafone faces some problem with regard to taxation, with regard to import of equipment, with regard to import of telephone towers made in UK, there will be no tax or there will be no double taxation for such things. Okay, so there will be no undue victimization. Okay, agreement on taxes will be there. The profits will be taxed only in one country. If Vodafone company takes 500 crore rupees profit from India after its India operations, after amassing Indian customers, having as many Vodafone connections, okay. So if 500 crore rupees is repatriated, is sent back to UK from India, it will be taxed only in UK. This is double taxation avoidance agreement. Agreement number 2 and 3 explained together, okay. Its investment will be protected. Bilateral investment agreement ensures if there will be a bilateral investment agreement between India and UK, it will take care of the investment protection of UK's companies in India. For example, Tata acquired, this is an example, real example, Tata had acquired Chorus Steel Company of United Kingdoms. So Tata's investment in UK will be protected under the bilateral investment agreement between India and UK. If there will be any dispute between UK's company and India's government, that dispute might not be decided in the Supreme Court of India, but that will be decided by international arbitration, out of court. Out of the legal system of UK and India, there will be independent arbitrators. Okay, so that is how the disputes are decided, guys. Okay, so this is the advantage of having a bilateral investment agreement. Then the third one, double taxation avoidance agreement. As I explained, that if UK's company is making profit in one country, then it will be taxed in one of the countries only. If profit is made in India, but there is a double taxation avoidance agreement between India and UK, then the profit will be taxed only in UK and not in both the countries. That is why the term double taxation avoidance. Okay, the double tax will be avoided. Clear? Now, global trade context, radical changes in the US trade policy are reshaping global trading order. The countries which were not forthcoming earlier, which was not willing to conclude these free trade agreements like India, UK, India, European Union, they are now agreeing to conclude these things. Sometimes it requires a catalytic reaction. Okay. Sometimes it requires some outside push. And Donald Trump's trade war is acting that outside push to initiate the trade deal. Okay. Now, India, US and India EU trade negotiations. Negotiations with the US are expected to conclude before the end of the current year 2025. India and the European Union have also agreed to sign trade deal within the same year 2025, thanks to Uncle Trump, right? Now, this is there. India, resumption of India UK FTA talks. This has happened. One important thing is earlier India had drafted a template. You understand a template? Every day I use the same PPT template. So this is a template for me to make the DNA every day. Okay, the news analysis. Similarly, India had drafted its own 2016 model bilateral investment treaty. That means this template that India made, model bilateral investment treaty, model bilateral investment treaty, okay, this will be the template for negotiations with any country that wants to sign, be it UK, be it Norway, be it any country that wants to be it Denmark, okay, or be it EU. Any country that will come to India, we will negotiate on the basis of the pre-drafted template. This template was drafted by India's Ministry of Commerce. The problem with this template is that this was drafted by India in 2016. The problem with this template is that in case of a dispute, between the company which invested in India, dispute between company which invested in India and the government of India, okay, the tax matter or anything, the state has been given weightage. That means the government of India is most likely to win the matter. The matters were this bilateral investment treaty was more favorable to government of India than to the investing company. Okay, for example, we had a dispute between UK's Can India, CAIRN, or UK's Vodafone, when Hutch was acquired by Vodafone and 11,000 crore rupees tax notice was sent to Vodafone. Okay, so in case the bilateral investment treaty was signed on the template drafted by India, then most likely Indian government will be at an advantage. Rather than being neutral, this bilateral investment treaty is pro government of India, is in favor of government of India. That is why now the Commerce Ministry is saying that the India signaled a stronger protections for foreign investors during the union budget announcement this year, that we will give more strong protection to investing companies because we want to attract FDI into India, because there will be a war against China. Tariff war already has begun against China and many companies are moving out of China. So we want to attract them to India because India requires foreign direct investment to generate employment, to generate revenue, to take India's revenue to take India's GDP to $5 trillion. That is why to attract these foreign companies, we have to redraft our 2016 model bilateral investment treaty, which was considered to favor the state in disputes resolution, which was perceived as favoring the state of India, government of India. Okay, for example, there occurred a dispute between Japanese company Nissan Motors. Nissan cars you see in India these days. Nissan Motors invested in Chennai, and later on there was a dispute between the Tamil Nadu government and Nissan Motors. In the decision given by the Madras High Court, the dispute was decided in favor of Tamil Nadu government. Later on, leading to a situation where Nissan Motors, the Japanese company, got annoyed, they got offended, and they said, we are going to wind up operations from Tamil Nadu altogether. This kind of investment climate sometimes is labeled as tax terrorism. Okay, India is labeled as not an investor friendly country because of tax disputes, because of frauds, etc., bribery, corruption by bureaucracy. That is why under the ease of doing business, when the World Bank ease of doing business index was there, we were striving, Indian government was making all the efforts to make sure that investors are enthused. Many a times we see that Rajasthan government recently conducted an investment fair. They signed MOUs worth thousands of crore rupees so that FDI is attracted into the state of Rajasthan or Haryana or Tamil Nadu or Telangana for that matter. Okay, so that is why now Ministry of Commerce is saying that while negotiating with all other countries, we will be revising our 2016 draft of a bilateral investment treaty so as to make it more investor friendly now. Okay, investor friendly. Clear? So this was all in today's news analysis. Overhaul of India's model BIT will be done. India's investment treaty negotiations are going on with a lot of countries now. This is all, the repetition of the same thing. With this, I wrap up the session for today, 21st of April. Civil Services Day related article was there. Let us quickly deal with that. Okay, this railways thing was also there. The Vande Bharat Express is prone to serious accidents even in cases of cattle run over. Okay, for example, if this very flashy looking, nice looking, modern looking the locomotive, okay, the engine collides with the cattle, with the buffaloes, crossing over the railway track, then it will do severe damage because of the lighter weight of the new locomotive, new engines. The Vande Bharat engines are designed in a manner that they look very swanky, stylish. yet they compromise on the security. So that is why Commission on Railway Safety, a very important point I'm going to make here, the leading coach of Vande Bharat trains is significantly lighter than the regular train locomotive. So you see regular train locomotive looks like a bull, but this itself looks like a calf, है ना? So that's the point. Now, Commissioner for Railway Safety. The report was generated by the Commissioner for Railway Safety. So this report highlights that we need to have something, we need to inject an element of safety in the Vande Bharat locomotives. Okay. Now, there is a topic given in your syllabus. I have incorporated this thing about Commission for Railway Safety. CRS is a government body that acts as a railway safety authority in the country. Okay. Its headquarter is located in Lucknow. Why is this important? See, Commission for Railway Safety, CRS, comes under Ministry of Civil Aviation. This is, my dear students, an India yearbook type of a question or knowledge, which is later on, it becomes very difficult to memorize. Why the Commission for Railway Safety is in Ministry of Civil Aviation? Imagine if this Commission for Railway Safety news has been given. I mean, if this Commission for Railway Safety would have been under Ministry of Railways, okay, then it wouldn't have been as critical about the safety. To ensure the independent functioning of Railway Safety Commission, it has been placed under ministry different from Ministry of Railways. Similarly, there are other road safety committee, etc. They are placed in Ministry of Railways. The subject matter transport remains the same, but the ministries are different. Why? Otherwise, the Commission for Railway Safety will become Commission for Failway Safety, right? So they will fail in their reports to criticize the Railway Ministry for any aspect of railway safety. So that is why. Okay. So please memorize this thing. That is how, and it caters to your topic in the syllabus GS Mains Paper 2, Ministries and Departments. So we often struggle as UPSC aspirants as to what is to be studied for this topic. For example, we covered the topic of Jal Jeevan Ministry, okay, Jal Shakti Ministry. So Jal Shakti Ministry, the change of the name, or for example, we recently in the last few years, we changed the name of the Ministry of Environment and Forest to Ministry of Environment and Forest and Climate Change. Okay, CC. So the very fixation of the very naming of the ministry in a manner, it instills a sense of purposefulness to the purpose of the ministry, to the objective of the ministry, that it is no longer a ministry taking care of the environment and forest only. It also has to take care of the climate change. Okay, Ministry of Agriculture, now renamed as Ministry of Agriculture and Farmers Welfare. Ministry of Agriculture is not going to take care of only standing crops, but ultimate objective is to double the income of the farmers. So likewise, Ministry of Ganga Rejuvenation, etc., these names are changed. This is how GS Mains Paper 2 topic can be covered well. Okay, so today's agenda was to jot down this factual information. Commission for Railway Safety comes under Ministry of Civil Aviation. India yearbook becomes very difficult to memorize at a later stage. On a daily basis, if we add a bit and piece of some information to our knowledge base, it becomes easier to memorize and it becomes easier to retain for until your preliminary examination. Okay. Now coming to Civil Services Day, even though Civil Services Day is today I'll be keeping a watch on the speech of the UPSC chairman of the government of India or any dignitary, Prime Minister of India. Already the Union Minister of DOPT or Minister of Pensions, Public Grievances, Minister of State Independent Charge, Honorable Mr. Jitendra Singh, has talked about the representation of girls in the civil services of 2023 batch. Okay, the officer trainees, it has got 41% representation of the girls. All right, which is a good thing, factual thing only. We'll wait for something more to come. Maybe some UPSC chairperson will give some speech today being 21st of April, Civil Services Day. So Sardar Vallabhbhai Patel related things are there. But what is the emerging trend? Emerging trend is about diluting the anonymity of civil servants. Okay, anonymity means they have to act from behind the curtain, behind the clock. Why can't they be given some recognition? Okay, today we see some civil servants, the frauds are, what are the themes basically? Let's understand the emerging themes in the civil services arena. The other day we saw Collector Bro in the Saturday's news analysis, wherein we saw that social media is increasingly being used by civil servants to blow whistle. Okay, there is no Whistleblowers Act in India to protect them from the corruption, to protect them from the onslaught if they level some, if they unearth, or if they blow the whistle around some corruption, around some scam, sand mining, mafia, etc. If it is happening, they blow some whistle against the ongoing malpractice, and then they are themselves, the honest civil servants, are victimized. Then we see a lot of instances of Pooja Khedkar. Okay, the cash stash 500 crore rupees found at the CA, one of the IAS officers, chartered accountants in Jharkhand. Lot of pujas are happening, hai na? I mean, that lady's name was also Pooja Singhal. Then we see Pooja Khedkar. So, civil services anonymity, should it be diluted in the light of the advent of social media? Or should the civil services rules 1954, should they be revisited again so as to recognize the social media rights of civil servants? In the light of the advent of social media, you see wherever Tina Dabi goes, the camera follows, right? Then wherever Deepak Rawat goes, camera is already there. He is already, I mean, well dressed. He is always, and then they say, I mean, then they nurture some political ambitions at a later stage. Okay, same is happening in Kerala with this collector bro and Prashant. So those kind of things are the emerging themes. Do we need to dilute RTI? That RTI is being diluted in the light of DPDP Act. These are the themes that we can talk about in the arena of civil services reforms, etc. Okay, do we need to have civil services boards, civil services board as suggested by second ARC to protect to protect the honest bureaucrats? Okay, so these are the themes, guys. We'll talk about this thing as and when some news article appears about the National Civil Services Day today. If some speech is made by Honorable Prime Minister of India or UPSC chairman, then we are going to discuss about that. Okay, this was all in today's news analysis. It was really a pleasure taking you through all the news articles. I hope you also enjoy it, but please answer all the questions. Otherwise, it is a one-way road which is prone to accident in the form of just listening and not learning. Thank you. Bye bye. Have a good day, guys. Thank you.